On the eve of closing arguments in Sean Diddy Combs' blockbuster criminal trial, the court was dark today, and yet there was plenty going on. Prosecutors announced that they are dropping certain predicate crimes supporting the racketeering charge. They include attempted arson, attempted kidnapping, and aiding and abetting sex trafficking. Plus, attorneys on both sides spent hours this afternoon in a charging conference with the judge. I'm criminal trial attorney Sara Azari, and this is Serving Justice. Today, we will break down what all of that means as we are reaching the end of this blockbuster trial. I'm joined today by criminal defense attorney Donte Mills and NewsNation digital reporter Safia Samee Ali, who's also an attorney and has been following this case closely from the very beginning. Thank you so much, Donte, for making time for us. And as always, thank you, Safia. I want to go to you, Donte, first. I was on your feed and you were in the thick of this today outside of the courthouse. In an 8-page letter to the court, the prosecution said that they are no longer pursuing special instructions or theories of liability, essentially these specific predicate acts that go to the racketeering charge, including attempted arson, attempted kidnapping, both under California and New York laws, and aiding and abetting of sex trafficking under federal law. And that they're doing so, supposedly in this letter, to comply with the judge's request for streamlined instructions that avoid jury confusion. I don't know. I'm not sure I buy that that's the reason. So I really want to hear what you got to say. Is that why they're doing this, or is it that they haven't met their burden?
Well, if you take that instruction from the judge to streamline it as come to me with things that you think you can actually win on, then yes, they are complying with that. They looked at this case after they presented it and said, we didn't prove that it was in fact Sean Combs who started the fire. I mean, we may have proved that, he may have wanted to or even threatened to, but we didn't prove that he started it. So we're not going to put that in front of the jury because we want to save some credibility for the things that we believe we can prove. And it's going to come down to who controls the narrative the most on this, because the prosecution is going to say, listen, we had other claims here, but we didn't throw all of that in front of you. We let it come out. And we're now bringing you what we believe we showed and what we believe you should find him guilty for. The defense on the other side is going to say, listen, they wasted everybody's time. They brought all of these charges. All of it was just made up and fabricated. And look at what's left. It's pretty much nothing. That's just proof that none of this should stand. And it's just a matter of who controls it better.
Yeah, and to your point, I always say it's not about what they brought before the jury. It's also what's missing. They have 2 victims of sex trafficking in this indictment that are nowhere to be found. The jury never heard from them. And then they also have a co-conspirator, very obvious one, Christina Coram, who never testified. So this jury's like, there's these like holes, and now you've got these predicate acts that were testified to that are gone. But I'm not sure. I've read the indictment, Donte, multiple times today, and I've read that letter multiple times. I'm not sure if they're just essentially getting rid of the attempted versions of arson and kidnapping, or are they getting rid of arson and kidnapping altogether? I'm reading it because in the indictment, paragraph 13 says, these predicate acts that they're listing, they say, arson, attempted arson, kidnapping, attempted kidnapping under California and New York, and then, of course, aiding and abetting of sex trafficking. Like, they're not getting rid of the sex trafficking. They're presenting evidence of that, but not the aiding and abetting of it. Are you reading this as like the whole predicate act of kidnapping and arson is now going to go away? Or the attempted...
I read this, those 2 things, the arson and kidnapping, will go away. From my understanding, if you're not going to put forward and you don't want that put forward to the jury, even as far as legal definitions and things like that, then I don't think it's going to be included at all. I think they're going to hang their hat on the prostitution, the sex trafficking, and RICO combination, and say, this is what we proved to you. We let everything else go.
It'll be interesting to see. I'm dying to see the actual instructions. Getting all this there's obviously all this dispute over what the instructions should
Even
look
some
like.
Of the definitions, I don't know if some of the definitions they asked for, where they said they asked for a definition that said, even if you're you don't have to be chained up or tied up in order for it to be coercion. Even if you received, if you didn't receive money, then it still can be prostitution. It's just weird
Yes.
definitions. They're trying to plug their holes with definitions and instructions to the jury. That's not how it usually works.
Right. And Safia, I always say that when the prosecution hasn't met its burden, that's where they're just reaching and grasping for these special instructions, because instructions are attached to the statute. So there are statutory instructions that go with the charge. But then when you ask for specific instructions, it's usually very tailored, very, it's minimal. It's almost like they're asking for like a whole new set of instructions that should be written so that they could meet their burden, right?
I mean, they cite precedent. They are saying that this isn't coming out of left field. That letter, they talk a lot about different case law where they're saying this is where the definition met here. This is where the definition met here. It's broad. I completely agree with you both. Like it's very broad. And they are definitely, looks like plugging holes, Donte, like you said, especially with the physical restraint and like the quid pro quo.
Yeah.
Let's see what the final result is, but they do seem to have a justification. It's not coming out of nowhere. They are saying, look, this is things that other courts decided. So let's see.
Well, and the case law is why this is taking so long today, because remember, we have an appellate lawyer. This man is blessed enough and rich enough to have an appellate lawyer sitting in on every day of his trial, researching, arguing, and really making an impeccable record for appeal should he be convicted of anything. And so she's going in there. We need another 30 minutes. We need another hour, because they're looking up the law to make sure that the judge is not, obviously he's the arbiter. He's going to decide what these instructions are. But, if there's any judicial error with regards to these instructions, that's a major problem.
Sarah, do you agree with this, that for the jury, this is a high profile case, so I think it makes them focus more on this, but I also, for the judge, when you have a high profile case that is going to be scrutinized, when you have an appellate lawyer sitting in that courtroom that is going to scrutinize every single ruling, you pay a little bit more attention to it, and you don't give grace that you normally otherwise would. So even with the jury instructions, adding special instructions, sometimes the judge is like, you know what, okay, we'll just put it in. But now the judge may say, listen, I have to go by the book. This is what's required by the law. There is no reason to go beyond it. So we're going to stick with what's required by the law.
Yeah, and that's why, our field producer, Tommy Cristaldi, who usually joins us here, couldn't make it because the court's running really late today. And all day they keep going back and coming back. She's asking for more time. And it's really because the judge also is going to have his clerk looking up this stuff to make sure, like you said, what he's doing is sort of as bulletproof as possible in case there's an issue later. See, it's interesting. I'm not exactly seeing it like you, Donte. I'm seeing it as they're getting rid of the attempted versions of the arson and kidnapping and the aiding and abetting of the sex trafficking, but not the actual arson and kidnapping. Because in the indictment, it said both attempt and actual. I think, and that obviously that's an effort to streamline, cause less jury confusion, because the jury's going to be like, did he attempt or did he actually do it? Which one are we deciding? So they're trying to make it less confusing. That's how I'm seeing it. Who knows?
I read it the same way as you, Sarah. When I read it, I saw it as that.
Yeah, but they are, they're definitely getting rid of, but I also think they haven't proven it. They haven't proven it. That was all speculative. There was female DNA on the car. There was no investigation or prosecution of the break-in into Kid Cudi's home or the arson of his car. So I think they're realizing, and they did throughout this trial. This trial took a lot of turns for the prosecution. They never thought they're going to be missing two victims, and they've been sort of, taking turns as they went along. And I always say trials are a fluid process, Donte, as you know. And so I think this is a sort of another thing at the end where they're like, okay, we really, like you said, they don't want to lose credibility.
The issue here, I think, was the issue from the beginning. They prosecuted a person, not necessarily a specific crime. I think they saw the video, they saw the physical abuse and said, this is a bad guy that needs to be prosecuted. Yeah. But they could not, because of the statute of limitations, prosecute him for the obvious crimes. Correct. So they went for something less obvious that they had to kind of piece together. And
Yeah.
that's why this case is so difficult. And I don't know if it was easy enough or easy as they thought it would, especially once they started losing witnesses and things like
Yeah.
that to piece
Yeah.
it together.
And I think it's so important that we're having this discussion about sort of the backdrop of all of this, the sort of the politics of this and bringing this case, especially a jurisdiction like SDNY, because I also think that this jurisdiction has recently had a lot of success in convicting high profile individuals for sex trafficking, racketeering, specifically R. Kelly. I know that those, his case involved minors and consent was not an issue, but still it was the idea that a music enterprise was a criminal enterprise. And this jurisdiction has had a lot of success doing that.
Senator
And
Bob
when,
Menendez.
yeah. And I think, to your point, like they would not be able to prosecute him on domestic violence. That's a California charge that is long dead because of the statute of limitations. So they're like, another, big name, celebrity who we can bring down in this jurisdiction because we're on a roll here. I definitely see it that way too. Okay. So Donte, what are the expected headlines for the prosecution's closing and what are the defenses? What do you expect the defense to argue? Obviously consent, but tell me both sides.
Yes, the prosecution is going to go with what they've been going with from the beginning, which is he's a bad person. They're going to probably play the video again in the summation, and they're going to highlight that as the example of force that he would show if you did not obey his commands. And that's what they're going to hang his hat on. He was a person he was this force. Yes, people wanted to be around him, but he also demanded things from people like you go get drugs, you bring in prostitutes, you participate in this activity. And if you don't, there will be some kind of a consequence. And that's what the prosecution is going to hang their hat on, while the defense is going to say that was his personal lifestyle and had nothing to do with the organization, had nothing to do with his business. He had sexual proclivities that he engaged with people who willingly participated, whether it was because he was paying their rent or whatever was their reasoning for being a part of it, they volunteered to do that and he never forced them to. That's where it's going to come to a head and the jury's going to have to decide one way or the other.
So, Safia, I also see this. I think the prosecution is going to come in with a massive PowerPoint presentation that lays out all of the elements and literally, like a flow chart going to the testimony and the documentation or whatever evidence there was in the trial to show that they've met, that they're checking all the boxes and meeting their burden. I think they almost have to do something like that. And I think it's probably going to be a little boring, the prosecution's argument. The defense obviously is going to be more colorful. I think that the defense, like Donte said, will definitely really, bring home the idea of consent, but also money grab is the star witness that they didn't put on. They didn't put on any witnesses, but to me, money grabbing and opportunity is their star witness. So they're going to really argue that and say, these people wanted a career. These people wanted support. Jane wanted a provider. She said it herself, So these people, if this was so bad, if he was such a monster, then they wouldn't stay. I mean, coercing someone into sex is one thing, but you never coerce them to stay in the relationship. How come they didn't leave? Because it wasn't that bad. This was part of the relationship. This was a lifestyle, like Donte said. Last but not least, I think they're also going to argue his addiction. His addiction is a mitigating factor for federal sentencing. It's a huge one, actually. But I think here, if you remember from a bunch of the witnesses on cross, the defense elicited testimony. Well, did he appear to be under the influence when he did that? Did he appear to be under the influence when he said that? And so they're going to try to argue that all this petulant blackmailing and threats and all this stuff that he did, that is not the man that's standing trial. That is the monster on drugs. And, ladies and gentlemen of the jury, he's been sober since he's been in custody, blah, 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 which is why the prosecution brought in all that evidence about when his hotel got raided, when he got arrested, he had the drugs and he had all that stuff. So they're going to say, he's never changed. He's not humbled. He's still
that can be used as an excuse. That's a tough one because you're putting yourself in a position where you're making the prosecution's going to say he's a bad guy. You're making him seem a bit worse as an addict. Yes, it works for sentencing as a mitigating factor, but when the jury's deciding guilt or not guilt, to say he was on drugs, it wouldn't be looked at as an excuse for his behavior. And I
Well,
think it's risky to kind of put that up
no,
there.
I agree. I agree. It's a sensitive one, but I think it can be subtly argued to explain that that is not his behavior. That's not like Sean Combs in his raw form. That's Sean Combs on drugs.
And not to say, listen, they knew this is who he was all the time, and they knew who they were dealing with.
Yeah.
They decided to be in the relationship or not. They knew who he was. They knew what they were getting.
That still doesn't excuse the behavior, though. Like I feel like you're right. They saw this awful video of Cassie being beaten, being dragged, and now to say, well, he was drunk or he was high at the time. I just don't know if I feel like the jury's going to be like, what? Now all of a sudden, that's all fine.
Yeah.
I don't know. I think.
Well, they are going to say that is domestic violence, and he should have been prosecuted for that. Although he paid off someone, so he doesn't get prosecuted for that. but that's a California law issue and not what he's standing trial for, right? But what about the instruction that really bugged the hell out of me? That the prosecution is seeking an instruction that essentially, what was it, that the coercion, that it doesn't matter that there was past consent. They don't need to consider. Yeah, they don't need to consider past consent. That's the whole relationship.
Yeah,
but consent can be revoked at any time, though, right? Like, I think they're trying to say that, maybe though she wanted to do it this time, but there were times where she said no, and she was forced to, or she was threatened to.
Yeah,
with those,
I think,
with those tapes.
but see, I think it's unbalanced, as the defense argued. I think you can argue that. But for an instruction, for it's almost like you're boxing the jury into finding coercion.
And almost in making them believe that you have to, I guess, actively get that consent every single time, like a verbal yes or something like that.
Yeah.
As opposed to what they're going to argue is he was given consent and this relationship just continued as it was.
Yeah.
And if they didn't want to do it anymore, then they should have told him that. Right?
They did, though.
Yeah, but no, but
there's points where they said no. There's points where they said, I don't want to do it. Or they said, I don't want to do it. I don't feel like doing it. So there is evidence where they say no.
but then they change their mind and they do it. Here's the thing. There were text messages where he is actually saying, are you sure you want to do it? I can't remember if it was to Cassie or to Jane or both, but there are messages from him saying, you're sure you're down for it or something like that. So look, those are in front of the jury too, and I think this is.
He also had videos, explicit videos of them, right? Where they thought if they didn't say yes, something could happen. Those videos could be leaked, given to somebody. So
yeah,
I don't think it's clear cut.
But this is my next point that was also in that letter that pissed me off, Donte, was the one where his knowledge doesn't matter. Like, did he know that they didn't want to do it? That's like, so now a man has to read your mind. The man
that's the tough part. And I think some of the testimony that came out, specifically say from Jane, where she said, I didn't want to do it, but I knew if I didn't, he wouldn't have me in his orbit anymore. So I did it anyway. Does that constitute, not giving permission, or her essentially not giving him the ability to do it? Because in her mind, she said, the only reason I'm doing it is because.
Right.
He's not supposed to, unless the jury gets this instruction, he's not supposed to have to try and guess that or
have a crystal ball. A crystal ball. Like, that's what I'm saying. This is really such a litmus test for where we're at with the post Me Too. I mean, do men have to read minds now? Like, it's like, are you down for it? Yeah, well, I don't know. But they eventually do it. They're seen on tape, really into it. The sex workers said they got no clues or cues that they didn't want to do it. They were enjoying themselves. So, like to your point, Safia, the mind can change, but then change back again too. And so,
it can.
Right. But then is the man supposed? I mean, listen, we're in trouble. If he's found guilty of sex trafficking, I think a lot of men are going to have to be spending time in prison in this country, because it's like, you got to be a mind reader. It's insane to me. Anyway. All right. I'm not a girl's girl. Can you tell?
Well, no, I don't think that's, I think, listen, consent needs to be given. I preach that to anyone.
Yeah.
But it is tough if you're saying that someone really didn't want to, they didn't express it, but because they really didn't want to, then you should have understood that and read that to be that you did not have consent. That's a tough burden. I don't know if the judge will put that on the jury, but if he does, if he reads that instruction that Sean Combs didn't have to know they didn't want to do it, if they didn't want to do it, that counts as forcing them, then I think Sean Combs, just like you said, a lot of other people may be in trouble.
Yeah, remember the Dodgers star player, last name's Bauer, I forgot his first name, but anyway, remember that he was this just didn't get filed as a sexual assault, but the girl had a lot of bruises. She was a fan that met him on Instagram. She was driving, 3 hours from San Diego to Pasadena to have rough sex with him. There were text messages about what she was asking him to do to her: choking, beating, dragging, gag balls, all of it. Right. And then she said, well, I felt like that was her thing at the restraining order hearing. So this was not a DA case that didn't get filed, but the restraining order, which was like a 2-week trial, said, I felt like that's what I had to do in the moment. So well, how is he supposed to know that? I mean, how, the text messages you're asking for it, you get there, you're into it, but now we're going to have to like process why you're saying yes. No, that's what I'm saying. No means no, then yes means yes. I'm sorry. This goes to both of you. Can we start reading the tea leaves? Because I think it's really fun at this stage of a trial to figure out what's going to happen. So we're dealing with racketeering, sex trafficking of Cassie, sex trafficking of Jane, and a violation of the Mann Act, which was prostitution across state lines. Guilty or not guilty, Safia?
Okay. I have two defense attorneys with me, so this is interesting.
No,
okay.
I want Safia's opinion, not a prosecutor's opinion.
Yes, 100%.
Wait, which one?
Transportation to engage in prostitution.
Correct. Okay.
That's, I think, I don't think
anyone's
contesting it. I would be shocked if he was not guilty on that. Sex trafficking on Jane, not guilty. Sex trafficking on Cassie, guilty. Racketeering, I've really been struggling with this one, but ultimately I feel like it's going to be not guilty.
Mm-hmm. Donte, you?
I'm one short. So I do think that there will be a guilty verdict on the transportation prosecution case. Like you said, they're not really contesting that. It's hard to contest. I think you have to, if you want to, on the defense side, keep your credibility. You say, listen, he did this. It's separate from RICO and everything else. It was just his sexual preference. But in fact, he did pay prostitutes and they traveled, and you have to kind of acknowledge that. But I think in acknowledging that, you say it had nothing to do with his business. It wasn't an enterprise. This wasn't a large kind of thing. It was.
And where's the co-conspirator? Right. Where's the co-conspirator?
There are no co-defendants. No. And you point to his business manager who came in and said, listen, we ran everything by the books as far as Bad Boy was concerned. Nothing, crossed over. I think he's not guilty on everything else because it's a very tough case to prove.
So I think we have a unanimous, we have a split verdict for sure. I think we all believe that there's a split verdict, but we have a unanimous verdict on the Mann Act violation, the prostitution across state lines for the purposes of sex. I think he's going down on that. I think he's not guilty on Jane, sex trafficking. I think that there might be a hung jury on Cassie, and I think he's not guilty of racketeering. But it's definitely a split verdict. We'll see what happens. And, the Mann Act violation carries 15 years, mandatory minimum. So, right, Donte?
Big verdict. And if there's people who are on that jury, and this is just honestly, just being practical. If there's people who are on that jury that saw that video of him abusing Cassie, heard some stories about him and thinks he's a bad person, that's an easy one for them to get a win on, to convince the other jurors he's guilty of something. And they may do that in exchange for the other jurors who aren't looking at it that way, that says we need him to not be guilty on something. That's practically how it may play out. They may just agree with that one easier case to prove, with the understanding that everything else is really muddied. So we're just going to let that go. And that's sometimes how a jury just, comes to an agreement.
I've been saying if I was on the defense team, I kind of would not be mad at the prostitution charge, even though he's obviously facing time for that, because, sometimes jurors, it's easier for them to find a bad guy guilty of something as opposed to nothing. So it gives them something to find him guilty on. But if they're struggling with the others, then they can obviously come back with a not guilty. Well, we shall
I'm just
see.
curious, since
Yeah.
since I've got both of you, I'm just curious. Had the other two victims showed up and testified, do you think that this case would have gone a different way? Like, do you think they would have turned it around and made it a little easier to get to Rico? Because they brought Rico. It was tough, but they chose to do so. And that must be
No,
for a reason, right?
no, so the other two victims were just two additional victims for sex trafficking.
Yeah, no, the other two people that would have came in wouldn't have went to. I think for Rico, they had to bring in more people that worked for the company that said,
AK.
he used our assets or other things for this. I think they would have had to broaden the scope of him getting, bringing prostitutes or drugs or to really go towards that RICO charge.
Well, you know what I think is going to be a unanimous agreement between the jurors is that the prosecution's overreached in this case. To what extent, we'll see how much they agree, but they're going to see that, two of their victims went missing. A co-conspirator, a major co-conspirator is missing. This is it's not a good look, for a prosecution. So that matters
It's
too.
not. But I think the prosecution made it clear.
Yeah, but when the defense gets up,
we could have gotten it with KK. If Christina Coram had shown up, then I think probably.
Yeah.
Okay.
Yeah, and I think that this gives the entree for the defense to argue. Really, this is a racketeering conspiracy. Where's the co-conspirator?
Right.
What, did he agree with himself? Is that another thing in his mind that's going on? Like, this dude's a major psychic.
Yeah, you heard from other people here saying it had nothing to do with the business. I think that's an easy argument for them to make. But I do think the prosecution just they prosecuted a person, right? Him. And they've made it clear that he's a bad guy. And I think they've convinced some of the jury enough that he should be found guilty for something. And I just think the easy one is the prostitution demand.
I agree. Donte, thank you so much for finding time for us today, because you were in the thick of it. And I was like, I have got to hear what he has to say.
I enjoy you. It's always a pleasure.
Likewise. And thank you so much, Safia. We will be back tomorrow. Thank you to our viewers who are following along. We're not getting off this case until however long Diddy's problems last, which is going to be a long time. We will be back tomorrow. And until then, the defense rests.